No, Your Honor.
No, thank you.
Just double check, make sure all cell phones are off around 5 degrees. Received. They're on the way, Your Honor.
Thank you.
How's the meeting doing today? How's the meeting doing? Good.
The jurors are in the building. All rise. You want them to go right in, Your Honor, if they want?
So yeah, if you need a few moments in the jury room, you can do that. Otherwise, we can come right back out. But if you do need a few moments, just tell us. It's fine.
If you want to close it, go ahead. If not.
Have a seat, jury. Jury, the door's closed.
Stay on the command.
Yes. Michael.
Sergeant Coles? All rise.
1:44 p.m. Perfect, thank you. Please be seated, everyone. Ladies and gentlemen, we're continuing with the testimony of Sergeant Coles. Sergeant, you're still under oath from this morning. Ms. Trung.
Thank you, Your Honor. Sergeant Coles, in addition to the calls that you testified about, did you review certain emails from the defendant's phone?
I did.
And that's the iPhone 11?
That's correct.
I'm showing you what's been marked as S121 for identification. Could you please take a look at that?
Yes.
Could you briefly describe for the jury if you recognize S121 and what it is?
S121 is a PDF report of 2 emails that were exported from Mr. Gregor's iPhone.
How do you know that?
I've seen these emails on the phone before. Yes, they're from his iPhone.
And is that an accurate report of the information that you have reviewed on the defendant's cell phone extraction in the past?
That's correct.
Okay. And how many emails are depicted on S121?
2.
Could you tell me the date and time of the first email?
Sure. The first email is on April 1st, 2021 at 4:47 p.m. That's from Elizabeth Dreisbach at njcourts.com.
And what about the second email?
The second email is on April 2nd, 2021 at 9:13 a.m. From Jed's Do Not Reply.
121 into evidence and have the witness describe it for the jury. No objection.
S121 in evidence. JEDS is the Judiciary Electronic Document System. I don't expect you guys to know all these acronyms, so that's what he's referring to.
So starting with the email on April 1st, 2021, what can you tell me from your extraction report there about that email?
Sure. I can see this email was sent to both Mr. Gregor and Ms. Michelot. The title was Michelot FD-12-1384-20 JOTSC, which was the FD would stand for Family Division of Superior Court.
Okay, and do you know if that email was read or not?
The email was read.
Okay. Do you know if there was an attachment to the email?
There was.
And do you know what the email was in regard to?
Filing within family court.
Okay. And on April 1st, 2021, it was an email received by the defendant and Ms. Michelot?
That's correct.
Okay. And that would have been, could you please detail what is described on S121 about the email?
Sure. The preview in the analyzer gives you a snippet of what the body of the email stated. In this case, it says, "Hello. Please see attached the court's order to show cause in the above matter. Please confirm receipt of this email and the attached order. Have a good weekend. Elizabeth Dreisbach, Law Clerk to the Honorable Patrick Bradshaw, JSC, Superior Court of New Jersey, Middlesex, Vinciage, 56 Patterson Street, New Brunswick, New Jersey, 08903, phone number 732-645-4300, extension 88263, from Elizabeth Dreisbach, elizabeth.dreisbach at njcourts.gov, sent Thursday, April 1st, 2021 at 4:21 p.m.
Now, with regard to the other email, could you describe that listed on S121?
Sure. Again, the snippet states, Superior Court of New Jersey, Ocean County. The following was filed by Christopher Gregor on April 2nd, 2021 at 9:13 a.m. Case caption, not available case number, not available docket text, complaint with order to show cause, emergent, submitted by Christopher Gregor, JEDS EF-641207. Transaction ID not available. JEDS EF ID EF-641207. Documents filed. Document type, document description, file name, FD complaint 11523 underscore 0 OTSC underscore EMERG underscore APP underscore OS see under -3.pdf.
Thank you. Can I just? And I don't recall if I asked you this. You told me with regard to the email from April 1st, 2021, when it was sent. Did you tell me when it was read?
I don't believe I did.
Okay. I'm showing you the exhibit again. Read it. S121. Is there a subsequent time listed there?
The status was read.
And you had testified about a time, I think it was 4/21. Is there a subsequent time listed with regard to that email?
The sent was at 4:21 from Miss Frasbeck. And received on device at 4:43.
What's that?
And again, the email was sent at April 1st at 4:21 p.m.
And you said the status was read.
That's correct.
Now, were you able to isolate any text messages on Ms. Michelow's Samsung Galaxy cell phone?
I was.
I'm showing you what's been marked as S5 for in evidence, S7 in evidence, S8 in evidence, S9 in evidence, and S11 in evidence. Do you recognize those documents?
I do.
Could you tell us what they are?
They are excerpts of the SMS conversation or text message conversation between Mr. Gregor and Miss Michelow from Miss Michelow's Samsung phone.
Okay. And have you seen all of those exhibits in the past?
I have.
And do they accurately depict the text messages that you extracted from Ms. Michelow's cell phone when you performed the extraction and reviewed the analysis?
That's correct.
I'm also showing you what has been marked previously for identification, I believe, as S10. Do you recognize S10?
I do.
Could you tell me what S10 is?
S10 is a text message or two text message between Mr. Gregor and Miss Michelow on April 2nd, 2021 at approximately 9:03:10 a.m.
Have you seen that before?
I have.
Is that an accurate representation of text messages retrieved from Ms. Michelow's phone on when you performed your analysis?
They are.
Your Honor, permission to admit S10 into evidence and have the witness read the defendant's text message. No objection.
S10 in evidence.
Just the defense message? Or both?
If you could read the defendant's text message, but both are on the exhibit.
I see. It's an incoming message from Mr. Gregor to Miss Michelow's phone on April 2nd, 2021 at 9:03:30 a.m. The message body states, "I am home. Let Corey walk into the house."
Thank you. Now, in addition to messages you isolated in Ms. Michelow's cell phone, were you able to isolate certain messages in the defendant's iPhone 11?
I was.
And were those from different time periods throughout April 1st and April 2nd, 2021.
They were.
Your Honor, can I place my stuff on the witness bench? Thank you. Showing you what's been marked as S136, S137, S138, S139, and S140. Could you tell me if you recognize those exhibits?
I do.
And generally, could you tell me what they are?
I can.
What are they?
So S136 is going to be a text message between Mark from DCP&P and Mr. Gregor's iPhone. This is an outgoing text to Mark at April 1st, 2021 at 5:17:49 p.m. The body of the message states...
I'm just going to stop you there for 1 second. Are all of these text messages in the exhibits that I showed you?
They are.
Okay. Where are they from?
They're from the SMS database on Mr. Gregor's iPhone.
Okay. And do they appear in the same condition as when you reviewed those text messages in the extraction?
They do.
All right. Your Honor, permission to move those into evidence and have the witness describe them.
No objection.
That's 136, 137, 138, 139, and 140 in evidence.
And Your Honor, I don't think that it applies to this bunch, but consistent with Your Honor's ruling and counsel's consent, the witness, I would ask to read both ends of the text message, if appropriate.
Yes.
So, ladies and gentlemen, the statements that are being made to the defendant from another party are hearsay, but as I indicated to you previously, it's often difficult to judge the defendant's response if you don't know what the other party's saying. So I'm permitting those to be read to you. You can't consider those for the truth of the matter. You can only consider those in the context of how the defendant is responding or interacting with the individual from DCP. Thank you.
With regard to S136, could you please describe to me exactly what that is now?
Sure. Again, that was an outgoing text to Mark from DCP&P. Message was sent on April 1st, 5:17:49 p.m. The body of the message states, "Hey, I can't get off work for tomorrow. I just asked my manager so I can go next week. Just let me know the number to call to schedule."
Could you please go on to the next? Is that S137?
S137. This is an outgoing text message to the 267-981-3533 number identified to be associated with Marcy Brogna. The text message was sent on April 1st, 7:48:54 p.m. The body states, "She has him at the hospital getting blood work, ... Not going to be back for a while."
And that's also sent from the defendant's phone?
Correct. That was a sent message to Marcy Brogna.
And S138, please.
Sure. S138 is going to be another outgoing message to Marcy Brogna on April 1st, 9:28:25 p.m. The message to the body states, "At police station now."
And that's from the defendant's phone.
That was from the defense phone.
S139.
S139 is another outgoing text message. This text message was sent to the number 516-617-3053, associated with the contact identified as Laura. This message was sent out on April 1st, 2021 at 9:35:27 p.m. The message to the body states, 2 hours late, she's not responding.
S140, please.
Sure. S140 is an outgoing text message to the contact identified as Amy, associated with the number 732. This message was sent on April 1st, 2021 at 10:17:20 p.m. The message body states, "Hey, so I'm going to take off work tomorrow because Corey's mom decided not to bring back from visitation, and I'm going to have to go to court tomorrow morning. Since Natalie isn't working, and who do I reach out to?"
Thank you. Now, did you review additional text messages from the defendant's phone from the morning of April 2nd, 2021?
I did.
I'm showing you what's been marked for identification as S141. (142), 143, 144, 145, 146. Could you take a look at those for me, please?
Okay.
Do you recognize them?
I do.
Okay. Generally speaking, what are those exhibits?
They are text messages from Mr. Gregor's iPhone.
Okay. And are they all from the morning of April 2nd, 2021?
They are.
And are they all representative of separate conversations or text messages?
They are.
And do all of those text messages and those exhibits accurately represent what you extracted from the defendant's iPhone 11?
Yes, they are complete copies of the messages that were sent or received.
Your Honor, the state's offering those exhibits into evidence, and I'd ask if the witness would be permitted to read them out loud to the jury.
No objection.
S141, 142, 143, 144, 145, and 146 in evidence.
Could you please describe S141 for the jury?
Sure. S141 is an outgoing text message to the 267 Brogna. Message was sent on April 2nd, 2021 at 6:48:19 a.m. The body of the message states, "She has yet to bring my son home."
S142, please.
S142 is another outgoing message to the Marcy Brogna number sent on April 2nd, 2021 at 8:36:08 a.m. The message of the body states, "She just dropped him off."
S143, please.
S143 consists of two text messages from the number The first one is received message to Mr. Gregor's device saying, "Yeah, that's pretty bad, period. Is he all right, question mark." That was sent on April 2nd, 2021 at 8:57:24 a.m. Mr. Gregor replied to that conversation. And I'm sorry, when I read this before, I read the sent number. That was Mr. Gregor's phone number. This text was from Marcy Brogna. And he replied to Marcy Brogna, yeah, on April 2nd, 2021 at 9:05:42 a.m.
Please move on to S144.
S144 is an outgoing text message to Mark DCP&P. The message was sent on April 2nd, 2021 at 9:49:20 a.m. The body of the message states, "Hey, I would appreciate a call as soon as possible this morning considering the events of last night."
S145, please.
Sure. S145 is an outgoing text message to the contact identified as Amy with the phone number 732. It was sent on April 2nd, 2021 at 9:53:25 a.m. The body of the message states, "He's home, but I still apply for an emergent application to remove any visitation moving forward."
And is there more to that conversation?
There is.
Overall, it's just directly to Mr. Reserve.
Sure. A reply from that text message states, good, it's from Amy at April 2nd, 2021 at 9:54:06 a.m. Body of the message states, good, did she say why she kept him? Mr. Gregor replied to Amy on April 2nd, 9:54:16 a.m. with the word nope. Amy then replied on April 2nd, 2021 at 9:54:32 a.m. with the question, he's okay though, right? And Mr. Gregor replied at 9:55:26 a.m. with the word yeah, yeah spelled Y-E-A-H-H-H with 3 H's.
And S146, please.
This is an outgoing text message to Marcy Brogna, the 267 2021 at 11:53:16 a.m. The body of the message states, well, since I took off from work and my son is sleeping, I'm just hanging out. How about you?
Thank you. In addition to those messages, did you review messages on the defendant's phone from the afternoon into the evening of April 2nd, 2021?
I did.
I'm showing you what's been marked for identification as S147, S148, S149, S150, S151, S152A, S152B, I just want to correct the marking if you could give me a second. Could I have a moment? Just to correct an exhibit number. Thank you. I don't know which number I left off at.
152 A and B.
Thank you, Judge. $153, $154, $155, 157, 158, and 159.
Sure.
Could you take a look at those and please tell me if you recognize them?
I do.
Generally, what are all of those exhibits?
They are text messages from Mr. Gregor's iPhone from the afternoon of April 2nd.
Okay. And are they all separate text messages or conversations, each of those exhibits?
They're all separate conversations. It appears they're all sent messages.
And did you review them prior to coming to court today?
I did.
And do they all accurately depict conversations that you observed in the defendant's extraction from his iPhone 11?
Yeah, the text messages are consistent with what the text messages were identified as.
Okay. Could you please go to S147?
Sure.
Please describe for the jury what is on S147.
S147 is an outgoing text message to the Marcy Brogna number on April 2nd, 2021 at 12:00:55 p.m. The body of the message states, "Nice. I might take a nap so I don't fall asleep at 10 p.m. on you, LOL."
Could you please move to the next one?
Sure.
S140.
Did you move those in evidence?
Judge, I'm sorry. I apologize. Permission to move those exhibits and have them read to the jury. Yes.
So the exhibits of what, 146 through 159, excluding 156, I think you did mention?
I didn't mention yet 155 and 156, and we already covered in the last group. We left off at 146.
Right, I have more of that.
So it's 147 through
So
the rest.
159 excluding 155 and 156?
Yes, Judge, thank you.
Any objection?
No. Could you please, I'm sorry, Judge.
S147 through S154 in evidence, S157 through 59 in evidence.
Could you please move on to the next one?
Sure. S148, this is an outgoing text message to Marcy Brogna. The message was sent on April 2nd, 2021 at 12:14:57 p.m. The body of the message states, "Do you desire a traditional pizza, Domino's, or Pizza Hut?"
Could you move on to S149, please?
Sure. S149 is an outgoing text message to Marcy Brogna on April 2nd, 2021 at 12:19:48 p.m. The body of the message states, "I am actually really excited to see you."
And S150, please.
S150 is an outgoing text message to Marcy Brogna sent on April 2nd, 2021 at 1:01:52 p.m. The body of the message states, "Well, just let me know when is the earliest you could come here."
And what about S151?
Sure. S151 are two text messages sent to Marcy Brogna. The first message was sent on April 2nd at 1:46:32 p.m. The body of the message states, "I'll be able to set it up. I've done it before. I'm just super excited to cuddle after destroying you." The second message states to Marcy Brogna at 1:46:35 p.m. in party.
Please move on to the next exhibit and describe S152A.
Sure. S152A is two text messages sent to the Marcy Brogna number. The first is an attachment of an image, and that was sent on April 2nd, 2021 at 2:06 p.m. And the second is a message stating, "Don't think I'm moving soon."
And I believe in that group at the bottom, there's a 152B. Okay. Judge, permission to show the photograph to the jury. Ms. Lento, if you could, the PowerPoint should be open already. You just need to advance to the next slide.
Sure.
Could you please tell the jury what S152B is?
It's a picture that was taken from Mr. Gregor's cell phone depicting him on the couch with Corey, who appears to be sleeping.
Is that the photograph that was sent to Ms. Brogna?
It was.
Okay, and what time was that photograph sent?
That photograph was sent on April 2nd, 2021 at 2:06 p.m.
Thank you. Could you please move on to S153?
S153 is an outgoing text message to Marcy Brogna on April 2nd, 2021 at 3:22:14 p.m. The body of the message states, "I'm so excited, haha," and so has 3 O's.
And S154.
S154 is an outgoing text message to Marcy Brogna, or 2 outgoing text messages to Marcy Brogna. The first one states, on April 2nd, 2021 at 4:44:42 p.m. Hey, something is going on with my son and I had to bring him to the hospital. The second message at the same time states, I'll LYK when I know what's happening. And LYK would be an acronym for let you know.
Could you please move on to
157?
S157?
Sure. S157 is an outgoing text to Marcy Brogna on April 2nd, 2021 at 2:13:59 p.m. The body of the message states, want to talk on the phone?
And could you please go on to S158?
Sure. S158 consists of 2 messages sent to Ms. Brogna. The first one was sent on April 2nd, 2021 at 12:23:13 p.m. The picture consists of a screenshot of the Pizza Hut menu. The second text message was sent on April 2nd, 2021 at 12:23:39 p.m. The body of the message states, hand tossed, thin crust, stuffed crust, or deep dish.
Could you please move on? S159.
Sure. S159 is another outgoing text message to Marcy Brogna. The message was sent on April 2nd, 2021 at 12:51:47 p.m. The body of the message states, you play chess, with 2 question marks.
And at the end of the text messages that I can take all of them back, that you just reviewed, were they out of chronological order?
They were out of order.
But are the times that you indicated for all of those text messages accurate?
They are.
And those are excerpts from the text messages contained in the defendant's phone.
That's correct. It's not the entire conversation between both parties.
And I'm showing you what's been marked for identification as S155 and S166. Could you take a look at those for me and tell me if you recognize them?
I can.
Could you briefly tell me how you recognize those?
They are sent text messages from Mr. Gregor's iPhone.
And have you looked at them before?
I have.
And are they accurate depictions of what you observed in the defendant's cell phone extraction?
They are.
Your Honor, permission to move S155 and 156 into evidence and have the witness read them to the jury.
No objection.
S155 and 166 in evidence.
56? Sure.
156?
156, I think I misspoke, Your Honor. 155 and 156.
Oh, you said 166 twice, I thought. So it's 155 and 156?
Correct.
The first text message is an outgoing text message to contact Laura with the number 151. The message was sent on April 4th, 2021 at 9:38:05 a.m. The body of the message states, on my way, with an exclamation mark at the end.
And that was S155?
That was S155.
Okay. Could you please describe S156?
Sure. S156 is another outgoing text message to the contact Laura we just mentioned. This message was sent on April 4th, 2021 at 11:17:14 a.m. The body of the message states, I'm here. Here is spelled Hereee.
Thank you.
All right, so correct. The numbers 156 is in evidence, 166 has not been used yet.
Correct, Your Honor.
Thank you.
When you reviewed the text messages in the defendant's iPhone 11, do they go back prior to April of 2021?
They do.
Do they go back to the beginning of the year?
They go back well beyond the beginning of the year.
What's that?
They go well beyond the beginning of the year. Well before, I guess is a better word.
And did you look through the defendant's contacts?
I did.
Did you see a contact labeled Mom?
I did.
Okay. What is the phone number associated with Mom?
Sure.
Can we just do the last 4 digits, maybe?
Yes,
Is
Judge.
that acceptable, both sides?
Yes, Judge.
Thank you.
8296.
Are there any text messages with Mom in the defendant's phone?
Not before April 1st,
Of what year?
2021.
Okay. Which date is that?
I believe the messages were on either April 3rd or April 4th of 2021.
There's nothing prior to that.
There's not.
Okay. And is there a contact named Dad in the defendant's phone?
There is.
And could you tell us the last 4 digits of that phone number, please?
Off of this, I can't recall the 4 numbers, but I cannot recall Dad's phone number.
Okay. Do you remember seeing the name Dad in the contacts?
I did.
Okay. And were there any text messages with the contact Dad in the defendant's phone?
There were.
What's that?
There were.
When's the first one?
And I believe it was on April 3rd of 2021.
So there were none prior to that.
Let's
That you
phrase it like this.
recall.
There were no messages prior as an individual conversation. There were some group chats that took place well before March of 2021.
Now, after reviewing the text log, were you able to review searches performed on the defendant's iPhone 11?
I was.
Okay. And were you able to isolate certain searches?
I was.
I'm showing you what's been marked for identification as S122. Could you take a look at S122?
Yes,
Do you recognize S122?
I do.
What is that?
They're identified as either searched items or web history from Mr. Gregor's iPhone's Safari web browser.
And is that all of the search history from the defendant's iPhone 11 or excerpts from the defendant's search history?
It's an excerpt of the searches from the date and time,
Okay.
or the time range.
How did those items get into S122 like that?
Like this. In this case, we did what's called a tagging within the Celebrate Reader software. We tagged the individual entries. We went to the tags portion and then exported out all the tags in reference to his search items and web history.
And are the items that are depicted on S122 accurate representations of what you reviewed as part of the defendant's search history in his iPhone 11?
They are.
Your Honor, permission to move S122 into evidence and have the witness read from it to the jury. No objection.
S122 in evidence.
Now, is S122 in chronological order or reverse chronological order?
Reverse chronological. The
Oh.
most recent is the highest on the entries.
Could you please start from the earliest date in S122 and describe for the jury the information that's there?
Sure. So the first hit in the Safari web browser on this was a search conducted on March 25th, 2021 at 9:36:31 p.m. The body of the search states, "Will red marks turn into bruises?"
And could you please move on to the next one?
Sure. The next search is on April 1st, 2021 at 8:43:36 p.m. The search was Neptune Non-Emergency Police.
The next one.
Next search was on April 1st, 2021 at 8:49:05 p.m. The search was Jersey Shore Medical Center.
Please move on to the next one.
The next one is a web history on April 2nd, 2021 at 3:08:37 p.m. The search was lost consciousness, sleepy and nauseous - Google search.
Please move on to the next one.
Next entry is April 2nd, 2021 at 6:10:22 p.m. The search was, can your phone be tracked in airplane mode?
The next one.
The next search was for April 2nd, 2021 at 6:10:35 p.m. for, can my car be tracked?
The next one.
The next search is on April 3rd, 2021 at 3:14:24 p.m. The search is, what causes a rise in blood sugar in white blood cells?
The next one.
Gotta rip your staple. Can't see the time. Next search was for April 3rd, 2021 at 3:55:40 p.m. The search is, could internal bleeding raise your blood sugar levels?
Please move on to the next one.
The next search is on April 3rd, 2021 at 3:56:55 p.m. The search is, how does gastrointestinal bleeding happen?
Could you please move on to the next one?
The next search is on April 3rd, 2021 at 4:28:21 p.m. The search is, how does gastrointestinal bleeding, how pong to die? It's P-O-N-G, to die.
Could you please move on to the next one?
Sure. The next search is April 3rd, 2021 at 6:55:22 p.m. The search is, can a GI bleed be slow?
Can you please move on to the next one?
Next search is going to be on April 4th, 2021. The value is McGee Tyson Airport, parentheses, TYS, and parentheses, comma, 2055 Alcoa Highway, Alcoa, Tennessee, 37701. Position is parentheses, 35.081033, comma, dash, 83.993889.
Is there a next one?
There is.
Could you please tell us what it is?
Next search was on April 4th, 2021 at 9:58:03 a.m. The search was, there was a murder determined from an autopsy. How long to file charges?
Is there another one?
The last one is on April 4th, 2021 at 10:21:16 a.m. The search was, how long after an autopsy to file charges get filed?
Thank you. Now, in addition to the text, calls, emails, searches, the things you saw on Ms. Michelow's phone, were you asked to analyze other data and render any opinions?
I was.
Okay. I'd like to go through those with you now. How many tasks were asked of you?
Sure, they proposed 7 questions to me they wanted to know more details about.
Okay, when you say they.
The state and the case officer.
And did you analyze all 7 of those tasks and render opinions?
I did.
Could you please describe to me what the first task was and what you did?
Sure. The first thing they proposed to me was to identify if conversations between Christopher Gregor and Brianna Michelow were deleted from Christopher Gregor's iPhone. If messages were deleted, please identify when they were deleted.
What did you do with regard to that?
So essentially, I opened up Ms. Michelow's phone extraction, and I opened up Mr. Gregor's phone extraction. On Mr. Gregor's phone extraction, there were 0 text messages with Ms. Michelow. On Ms. Michelow's phone extraction, there were 3,466 text messages saved with a conversation with Mr. Gregor. That was the first indicator that something was deleted from Mr. Gregor's phone. I looked at the message retention settings within Mr. Gregor's iPhone and saw the value for message retention duration on his phone was set to forever, as in messages would not be deleted unless a user did it themselves. In order to kind of really dig in to make sure they were received on this device, I opened up the SMS.db. That's going to be the text message database for Mr. Gregor's iPhone. And to give you an idea of what a database is or what it looks like, the best way I can describe it is to compare it to a Microsoft Excel spreadsheet. The Excel spreadsheet is going to have multiple rows and columns. On Excel, you can have different pages, and essentially inside of the database, there's going to be different tables. These tables cross-reference with what's known as the primary key, where you can search additional data from different tables by referencing the primary key ID of an entry. Databases will generally run sequentially, as in they'll go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If there's gaps in the sequence, it's indicative that content is no longer present on the device. Whether that means it was automated or automatically deleted by the phone itself, or if a user might have gone in and deleted the entry. So in this case, what I did is I opened up just 6 random messages from Ms. Gregor's phone that were sent to Mr. Gregor's phone. I compared the native timestamp of when those messages were sent from her phone, and I corresponded that with the text message database on Mr. Gregor's phone. And during that, I identified a sequence gap of approximately 7 messages, which would be consistent with entries that would have been there from Ms. Michelot's phone. I repeated that again, picking a random message, searching Mr. Gregor's iPhone's text message database, and identified that the time of a sent message from Ms. Michelot's phone was consistent with a missing entry from Mr. Gregor's phone. Last thing I did is I checked to make sure that Ms. Gregor's contact was not blocked at the time when I received the phone, and her phone contact was not blocked.
Sorry, can I stop you? Do you mean Ms. Brianna Michelot?
I do, yes.
Okay.
So Ms. Michelot's phone number was not blocked by Mr. Gregor's iPhone. So based off this, seeing as there were missing gaps in his text message database, consistent with messages that were sent from her phone, it's my opinion that Mr. Gregor deleted the text message conversations with him and Ms. Michelot on his phone. I have no way to tell you when those messages were deleted.
And that's the opinion that you rendered with regard to task 1.
It was.
And were you able to print out all of the text correspondence between Ms. Michelot and the defendant from Ms. Michelot's extraction?
I did.
Approximately how many pages was that?
880.
So 880 pages of text messages were gone from the defendant's phone.
That's correct.
What was the next task that you were asked to complete?
So when the case officer was reviewing the phone extraction, they notified there was really no messages sent or received to the device between the afternoon or evening of April 2nd of 2021 until approximately 2 o'clock on April 3rd of 2021. Their primary goal was to identify if the phone was either shut off or what the status of the phone was during that time frame.
And what did you do with regard to that second request?
Sure. So the first place I really went to was, it's called the KnowledgeC.db database. KnowledgeC at the time was mostly like an event logging feature of an iPhone tracking different activities going on that device. I looked at the device being unlocked, and I could see that his device was unlocked multiple times between the hours of approximately 7 p.m. until 7 p.m. on April 2nd until 1 p.m. on April 3rd. In addition to looking at the KnowledgeC logs for device being unlocked and locked, I went to what's known as the routine D or cache.sqlite. This database is going to be where your phone is storing what's known as significant location data. Significant location data is going to be data that an iPhone is going to use to help with predictive traffic routing or to help set memories in your photographs. During this time frame, from the evening of April 2nd until the afternoon of April 3rd, there were approximately 60,000 GPS fixes. GPS fix essentially being a ping for where that phone was. These logs will not generate if the phone is powered off. And I can identify that the phone could be tracked all the way from New Jersey down to the southwestern portion of Arkansas. And the last thing I did to review this was I went to check the actual airplane mode status. Within the KnowledgeC database, I specifically searched for the airplane mode flag, and I could see the phone was placed in and taken out of airplane mode several times during that evening. The most notable being The phone was placed in airplane mode on April 2nd at 6:38 p.m. and it was not taken out of airplane mode until 2:13 p.m. on April 3rd.
Did you render any expert opinion with regard to that second task that you were asked to perform?
I did.
What is that?
So based off the device being unlocked, these GPS fixes being generated, which will not happen when the device is powered off, and the fact that the device was in airplane mode, it means the device was powered on and being utilized. However, no messages were sent or received due to the device being in airplane mode.
What was the third task that you were asked to perform?
Sure. So there was a picture we saw before of Christopher Gregor and Corey Michelot sitting on the sofa with Corey appeared to be asleep. They want to know if that picture was taken at the date and time the message was sent.
And are you referring to S152B?
I am.
Say that.
I am.
Okay. Could you please tell me what you did with regard to that task?
Sure. So I found the original text message containing the photograph and then identified the source file path of the photograph itself. It's kind of hard to read this file path. The file path is going to be private/var/modbile/SMS/AAF7-A5-42907955243 underscore 6F47F270-8840-06DFF770F39.HEIC.
What is all that?
Exactly. So that is where the phone was saved on the photograph was saved on the phone itself. Based off this, HEIC is going to stand for High Efficiency Image Codec. That's going to be the native format an iPhone is going to take a picture in. The fact that this picture was in this directory would be indicative that the picture wasn't taken through the camera application. Rather, he had the text message open and took the picture he took the picture through the text message application. So essentially what I did is I went into the photos.sqlite database, which is similar to the another database where we cross-reference data and identified the Z creator bundle ID of the photograph was again com.apple.camera.camera messages app, and I could identify that this picture was taken on April 2nd, 2021 at 2:05:52 p.m.
So with regard to the third task, your opinion would be that the picture was taken on that date and at that time?
That's correct.
Could you please move on to the fourth task?
Sure. There was a video identified on Brianna Michelot's phone on April 2nd, 2021 at 9:02:50 a.m. Case officers want to know if this video was taken on that device and if there's any location data to identify where that video was taken.
Are you referring to S15A?
I am.
Please continue.
So I went into the phone's gallery, identified the specific video. It was located at the directory, data/media/0/DCIM/camera/2021-0402_090215.mp4. That is consistent with the native camera app on a Samsung Galaxy phone utilizing an Android operating system. I then went into the gphotos0.db. I just mentioned the photos.sqlite database from an iPhone. The gphoto0 would be the equivalent on an Android phone. I identified that the capture timestamp of that picture was taken at 9:02:50 a.m. This would be an instance where the time is actually in Eastern Time. And there's also a UTC timestamp with that, which is exactly 4 hours faster. Throughout the database, there's also an entry for location data. It was a null value, as in there was nothing there. So this phone had this video had no location data associated with it.
So So with regard to the fourth task, did you render any expert opinion?
I did. The video was taken at the date and time. It was reported to be at 9:02:50 a.m. And there is no GPS location data associated with that video.
What about the fifth task? Were you asked to perform the next one?
I was. So the next task involved the Grubhub application to identify if there's any transactions on Grubhub during the afternoon of April 2nd of 2021 between the hours of 1 p.m. and 3 p.m.
Could you tell me what, if anything, you did to look into that
Sure.
task?
So the first thing I did is I started digging into the Grubhub system, all the Grubhub files within the file system of the phone, trying to search for any databases that actually contain transactions. I could not locate any. I believe that would be indicative that the searches would be stored on Grubhub servers on a cloud, not on the device itself. However, there was activity to indicate that Grubhub was utilized on this device during that time. So what we started to do is look at the application usage logs on that phone, and I can see that the Grubhub application was utilized for approximately 12 minutes and 27 seconds between 1 p.m. and 2 p.m., and that Grubhub was utilized for approximately 2 minutes and 39 seconds between 2 p.m. and 3 p.m. In addition to the application usage logs, there were also text message artifacts that would be associated with Grubhub. For instance, there was a received message on April 2nd, 2021 at 1:54:04 p.m. From the short SMS number, or short code SMS 303 states, McDonald's is preparing your order to be delivered between 2:20 p.m. and 2:30 p.m. Track your food online or with the Grubhub app, grubhub.app.link/SMS. There's another message after that says your order is on the way and will arrive between 2:20 p.m. and 2:30 p.m. That was sent on, or that was received on April 2nd, 2021 at 2:14:34 p.m. And the third message was your Grubhub driver will arrive with your order soon. To keep everyone safe, please wear a mask. This was received on April 2nd, 2021 at 2:16:34 p.m.
Did you render an opinion with regard to that fifth task?
I did. Based off the Grubhub app being utilized and the device receiving text messages from Grubhub in regards to an order being placed, it's my opinion that the device was utilized to place an order through Grubhub, specifically to McDonald's as referenced in the text message.
And what was the time frame? Were you able to determine a time frame?
Of when it was utilized?
Yes.
Yeah, it was going to be primarily utilized between the hours of 1 p.m. and 2 p.m. and the hours of 2 p.m. and 3 p.m. for approximately 2 minutes. So overall, the app was utilized for roughly 15 minutes between 1 and 3 p.m.
With regard to the sixth task, what were you asked to do?
Sure. Before we reference the text message to Marcy Brogna, let me read the task. Please identify a screenshot of a Pizza Hut menu that was sent from Christopher Gregor's iPhone on April 2nd, 2021 at 12:23 p.m. that was sent to the number 2.
Did you do anything in that regard?
I did. So in this case, I pulled up the text message to Marcy Brogna that depicted the Pizza Hut menu. I identified that the picture was identified as img_4862.png. The img_45, or img_XXX is going to be associated with something saved natively to the device's gallery. The extension PNG is the proprietary form, or not proprietary, is the format that Apple uses when you save a screenshot on your phone. I went into the photos.sqlite database and identified the file name associated with img_4862 and identified that the screenshot was taken on April 2nd of 2021 at 12:23:08 p.m. I then cross-referenced that with the Z additional asset attributes table. Identified the Z creator bundle ID was com.apple.springboard, which is associated with the device's home screen, or the screen on the device.
What, if any, opinion did you render in regard to that task?
There's still a couple additional things I did for that. In his web history, there was no web search for Pizza Hut on April 2nd. However, in this case, there was additional database in his Safari browser called the favicons.db. The favicon is going to be the little picture on your web browser associated with that website. For instance, if you go on google.com, you'll see that little G in the corner of your web browser tab. If you go to Facebook, you'll probably see the little F in the corner of your tab. That is what a favicon is. In this case, I referenced Pizza Hut within the favicons database and identified a timestamp that shows Pizza Hut was accessed on this phone on April 2nd, 2021 at 12:22:17 p.m. So based off this, it was indicative to me that the picture was taken on his device on April 2nd of 2021.
At what time?
12:22:17 p.m.
Okay. And what about the seventh and last task that you were asked to perform?
Sure. The last task involved deleted search history that was identified within the Safari web browser. The initial terms that were identified as deleted were Neptune, not emergency police, Jersey Shore Medical Center, lost consciousness, sleepy, and nauseous. So what we wanted to do is go in and verify that these records were deleted and to identify when they were deleted. So in this case, I saw inside the physical analyzer software, if an entry is identified as or detected as it might be deleted, there'll be a little X in a column which represents deleted artifacts. So the first thing I did is opened up the actual database associated with the Safari web history and identified the date and times of these entries and identified that there were no entries locally in the Safari database. Before, when I talked about sequence gaps, I've reviewed the raw database and identified that there were sequence gaps present in his Safari database, which would have been consistent where these logs would have originated from, or that time they would have been originated at. So in this case, when you're using Physical Analyzer software, you can click the source file and it'll open up the raw database and show you where it found what it's talking about. So in this case, with the Neptune non-emergency police, I opened up the database and found the raw search still saved in there. So while it's no longer logically available in the database tables, that spreadsheet I was talking about before, the raw text was still available in the database. And most important thing to do is when you have a deleted artifact is to verify and validate the times being reported are accurate. I identified for the Neptune police, or excuse me, the Jersey Shore Medical Center, Google search, I identified the time offset. In this case, the time isn't stored in plain text that me or you look at on a daily basis. The format that this time is stored as, encoded as, is called double precision floating point format. So it's a string of hexadecimal characters, which then corresponds with a text or a plain text value, or excuse me, let me rephrase that. It converts to a plain text value that we would see. In this case, a timestamp is going to be in MAC absolute time. This is the format that an Apple iPhone is going to save dates and times in. So it's not saving in dates and times like we look at date and times. For this specific entry, the date entry was identified as 639017345.49637496471. This is going to be the number of seconds or milliseconds since January 1st, 2001 UTC, which would be 0000. For us, if we were to look at that time, it would depict December 31st, 2000 at 7 p.m. if we were to look at it in our time zone. So what I did is I converted that and verified that the time value was equal to what it was being reported as. So I could see that the search for Jersey Shore Medical Center was conducted on April 1st, 2021 at 20:49:05 p.m. I repeated that process for the other searches, such as the Neptune non-emergency police. So I can tell that search was conducted on April 1st, 2021 at 20:43:36 p.m. And I repeated the same process for lost consciousness, sleep, and nauseous, and could tell that search was conducted on April 2nd at 3:08:37 p.m. While these searches were deleted, I don't really have an accurate way to tell you when these were deleted. There's no way that I know of currently to say this was definitively deleted at this date and time.
Would it be true that you have to delete a search after you perform it?
The searches were deleted after they were conducted.
Okay. So with regard to task 7, your opinion would be that the lost consciousness, sleepy, and nauseous was deleted after it was performed.
That's correct.
Is it a good time to take a break?
Your Honor, yes, we could take a break. Thank you.
Unless you're about to be done, you can direct, but, well, that's fine. If you're not, you can come back out.
Your Honor, I have no further questions for the witness.
All right. Any objection to the break in?
Not at all, Judge.
All right. So, ladies and gentlemen, let's take our mid-afternoon break. Please don't discuss the case before the opinions.
All rise.
All right, thank you. Please be seated. Before we take a break ourselves, a couple of issues. Sergeant Dugan went over and had the jurors on either side of juror number 12 give him a little nudge. His eyes appeared to close briefly. He's wearing glasses, so it was tough to tell, but he did appear to startle when they nudged him, so he may have dozed off. Counsel, any position how you want me to address that?
Judge, I don't know how long he was asleep for, so I will defer to you. I know that once your court staff did notice he was asleep, they made progress very quickly to make sure that he wasn't.
Would you like me to interview him, or?
No, I'll defer to you, Judge. If you think he should be interviewed, interview him. But I don't know how long he was asleep for. Do you know how long he was asleep for?
I'm going to defer to Mr. Gallucci and Your Honor. I was asking the witness questions. I did look over at a period of time, especially when my attention was drawn to what was happening. But I'll defer to Your Honor. From your perspective.
Anyway, and the testimony is very technical. He's reading these different hash values or...
Yes, the 40 letters and
Right.
numbers towards the end. Yes, that was very long.
All right, well, without a request to interview him, I don't want to make it a habit of always interviewing jurors. For the most part, I find they're all paying attention. Just give me a moment.
Just figure out my...
Addressed previously in case law. So courts are required to take corrective action if someone notices a sleeping juror. See, for instance, State versus Scherzer, SCHERZER, 301, New Jersey, Super 363 at 491, a television case in 1997. Here, court would like to thank Sergeant Dugan for going over and advising the other jurors to give juror number 12 a nudge, which they did. He immediately came to attention. I then watched him closely for the remainder of the testimony until we took a break, and he did not appear to nod off or doze off. So the burden then shifts to counsel for either side to ask the court to take some type of action. Again, if you want me to take any action, I will. But absent that request, if I'm satisfied that you're been paying attention and continues to pay attention, there's no need for any action. See also State versus Muhammad, 226 New Jersey, 71 at pages 87 and 88, a 2016 New Jersey Supreme Court case. So again, while the jury's not here, does anyone have any requests for me to take any action or interview the juror?
Not at this time, Judge. But we'll keep an eye on him, and we'll come to habit. Maybe change my mind.
All right, we previously discussed giving an instruction on deleted text messages, and I believe Ms. Ferranti is dealing with this, so I think that needs to be expanded to deleted text messages and deleted search history.
Yes.
In addition, there also is an issue related to, but slightly different than the deletions. It's that the post-offense conduct of internet searches. which occur, according to Sergeant Coles, April 2nd, 3rd, 4th, and so on. For instance, about medical issues, or can my phone be tracked? As I said, that is similar to, but not exactly the same as deleting them, still post-offense conduct. It's come out in front of the jury. All this was previously dealt with as part of 104 hearings, and counsel asked me to defer a final ruling on these until such time as the testimony came out in front of the jury. One of the cases I'm guided by is a case called State v. Rochat, R-O-C-H-A-T, 470 New Jersey Super 392. It's an appellate division case from 2022, and that deals with, among other things, post-offense conduct, and indicating that, like deleting messages or search history, that can be relevant to consciousness of guilt, but it probably requires a limiting instruction. I shouldn't say probably. All these things require limiting instructions to identify for the jury the permitted and prohibited purposes of that evidence. So do you want us to try and do a separate limiting instruction on this internet search history post the child's death, or do you want to combine this all in deleted text messages, deleted search history, and search history in general? We just tried to, my law clerk and I were just drafting a limiting instruction on the search history as that was going on. Keep in mind, no one's requested this of me, but I believe that I'm supposed to bring this up since we're talking about other conduct apart from the time of the offense.
Can I have one moment?
Sure.
We would ask for separate charges for those two scenarios, just to make sure there's no confusion amongst the jury in terms of the charges itself.
All right, so in terms of the deletions, though, can we say deleted text messages and internet history in one, and then internet history in the other?
That's fine.
Or deletions from
That's fine.
phones? Okay. Absolutely. No objection if the witness use the restroom?
No, not at all.
Thank you.
If I can, I'm going to ask to see S136 from the people.
Right.
I'm sorry, let's see. 159. I do already have in my possession S10, I believe also 155 and 156.
Can I see what you have there? I don't know which ones you have already.
I have the
I'm gonna just hand you. I'm gonna just
Two
hand.
additional limiting instructions for you that we just discussed. The council reviewing them, and I'll give it to the jury before the
As long
cross-examination.
as I
Does that
can
mean
hold
one?
that.
Or after the cross?
I should have got that, so.
That's okay.
before the cross, please.
All right. Can I have that? Your Honor, may I approach and just collect the exhibits so I can have them for reference?
Certainly.
Thank you. Don't let him organize. I did that last time.
You're not allowed to organize.
So these are my exhibits. Huh?
Yes.
Right. Not right now. Thank you. He got his, I have his CV, but I know he has his report. Does he need his notes back in his other report?
I don't need those notes.
Okay.
Or maybe let me have the other report too.
Shannon. Sorry. He did say he wanted these. Thank you.
Is that both or notes on the report?
What's that? Notes on report
All
right
right.
there.
If we need it.
Okay.
Yeah, that's right.
SQ light. SQ light. S just capital S, capital Q, LITE. We see SQLite. Yeah. I've gotten slower, but my enunciation's not.
Limiting instructions. One is titled Internet Searches. The other one is titled Deleted Internet History Under Text Messages. Court staff needs a brief recess, so we'll take a break and come back to that. I'll hear from either side any objections or concerns. It's acceptable marking as court exhibits, and then I'll advise the jury of those instructions before this hearing additional testimony.
Thank you, Ron.
All rise. Step out.
I have to use these ladies.
Yeah.
And I'm going to
I'm
step
gonna
outside for 5 seconds.
Okay. Do you need me? Do you need to?
courtroom is open, but the jury is still in the jury room. Ms. Ferranti, any position on these two proposed instructions?
I was going to request a conference of people before stepping back on record. The way part of the instructions are phrased, fourth paragraph down when it comes to internet searches, and then the deleted history and text messages, third paragraph down, if you find the defendant's explanation credible, I just have a concern with the way that is postured because we don't know what's going to come out during the cross-examination and what explanation, if any, might be given. So I just don't want to get into an issue where the jury believes they have to hear that or something from the defense.
Judge, I had an issue with that, and I also had an issue under internet searches, the third paragraph down. If we could just use the second part of the sentence on deleted internet history and or messages that says the defense has suggested there are explanations for the deletions on both instead of, if we could use the defense may provide some explanations for these searches instead of the defense has suggested, because we don't know what they're going to do, and cross-examination isn't necessarily like what it purports to be. And I think, obviously, like in a final charge, these might be different after the defense has finished their case, but not mid-trial.
All right, so starting with internet searches first. Third paragraph. Currently says, quote, the defense may provide some explanation for these internet searches. If you want to say, although not required, comma, the defense may provide some explanation for these. Although he is not required, the defendant may provide, or the defense may provide some explanation for these internet searches. So that'll be changed to, quote, although he is not required to do so, the defense may provide some explanation for these internet searches. Next sentence. If you find the defendant's explanation credible, you should not draw any inference of the defendant's consciousness of guilt from the defendant's internet searches. That language, if you find the defendant's explanation credible, is basically from the model charge on flight or post-offense conduct. Do you want me to modify that somehow?
I do. I just don't have a suggestion of no one on counsel to make it clear that he has no burden of proof and is not required to offer an explanation.
Well, we can certainly change it to any explanation, but if you find that the internet searches are not helpful to you in this case, or if you find any explanation by the defendant credible, you should not draw any inference.
That would be acceptable.
Judge, can you say that again? I'm sorry.
Let me write it out.
Yeah.
Do it. All right, so the revised fourth paragraph on the charge entitled Internet Searches would read, quote, if you find that the Internet searches are not helpful to you in this case, or if you find any explanation by defendant is credible, you should not draw any inference of the defendant's consciousness of guilt from the Internet searches.
Okay, Judge. So you're just adding that one part to the front.
All right, so now, while we're changing that around so we can pass it out to counsel, going to the next one entitled Deleted Internet History and or Text Messages. You want to use that same language about, although not required to do so?
Yes.
This is before. Just go back to something on internet searches. I'm sorry. I don't want Ms. Grimaldi to finish. And then in the first paragraph, it says, you have heard testimony and evidence was admitted that a phone owned by and subscribed to by the defendant was utilized to search the internet using certain internet search terms, and that this occurred after the date set forth in the indictment. It was before and after one of the dates. I just didn't want it to be misleading in any way. There was a search that was testified to on April 25th, the first day in the indictment. So I just wanted to bring that to the court's attention. And the
Searches
subscribe.
on April 25th and April 1st would not be post-offense conduct. They'd be intrinsic to the crimes charged.
Okay.
And would not, in my view, really require limiting instructions then, because it's contemporaneous to the alleged acts. It's the offenses after the child's death, the conduct after the child's death, which would require limiting instructions. I don't want to start.
Understand, Judge.
The communications and all these things happening between the parties are clearly relevant to what's happening. Ordering McDonald's is relevant to whether or not he's harming the child at that time or whether he's ordering the child food. But that's different than what he's doing the next day when he's allegedly going to another state and or doing his internet searches. So I'd rather keep the instruction confined to after the incident in the indictment, because that's when the instruction's required. Let's work on a deletion instruction. Revision for the part about the deletions. We're going to try and get them printed and handed out to you right away. Can you give me a printed please today?
Yes.
All right. Then we've already 3:20. So.
Yeah.
I'm just asking because I know you have a witness from out of state tomorrow, so we need to juggle things around. Let's talk about it before we recess for today.
Yes, Judge. I was speaking to Mr. Gallucci before about if it was necessary, if counsel wanted to ask Your Honor, if rather than having this witness come back for 5 or 10 minutes, we could finish it today. But I told counsel to ask Your Honor if he thought that that was appropriate.
Let's see how far we get. Position from defense on the instructional title of the searches.
I think both are acceptable, Judge.
Okay, both are acceptable. Madam Clerk, court's exhibit next in order with internet searches first, deleted internet and text second.
What are they marked, please?
Internet searches is C11 in evidence, deleted internet history under text messages is C12 in evidence. So, any before bringing jury back out? Very good. 3:23 p.m. jury back out.
All rise. Jury out.
Thank you. Please be seated, everyone. Ladies and gentlemen, before we go to the cross-examination, there are a couple of additional instructions that I need to give you. The first is regarding the internet searches that you heard about. You have heard testimony and evidence was admitted that a phone owned by and subscribed to by Christopher Gregor was utilized to search the internet using certain internet search terms, and that this occurred after the date set forth in the indictment. The question of whether the defendant made these searches is another question of fact for your determination. If you find that the defendant, fearing an accusation or arrest would be made against him on the charge involving the indictment, made those internet searches, then you may consider same in connection with all other evidence in this case, as an indication or proof of consciousness of guilt. There has been some testimony in this case from which you may infer the defendant made certain internet searches from his phone. Although he is not required to do so, the defendant may provide an explanation as to his internet searches. If you find that the internet searches are not helpful to you in this case, or if you find any explanation by the defendant is credible, you should not draw any inference of the defendant's consciousness of guilt from these internet searches. If, after consideration of all the evidence, you find the defendant, fearing that an accusation or arrest will be made against him on the charge involved in the indictment, made those internet searches, then you may consider same in connection with all other evidence in this case as an indication or proof of consciousness of guilt. It is for you, as judges of the facts, to decide whether or not the evidence of the defendant making certain internet searches shows a consciousness of guilt, and the weight to be given to such evidence in light of all other evidence in the case. And there's a second instruction regarding deleted internet history and or deleted text messages. There has been some testimony in the case from which you may infer that the defendant deleted text messages and or internet searches from his phone. The question of whether or not the defendant deleted anything from his phone is another question of fact for your determination. If you find the defendant, fearing an accusation or arrest will be made against him on a charge involved in the indictment, deleted contents from his phone, then you may consider same in connection with all other evidence in this case as an indication or proof of consciousness of guilt. There has been some testimony in the case from which you may infer that the defendant deleted some items from his phone. Although he is not required to do so, the defendant may provide an explanation for the deletions. If you find that the deletions are not helpful to you in this case, or if you find any explanation by the defendant is credible, you should not draw any inference from the defendant's consciousness of guilt from the defendant's deleted content. If, after consideration of all the evidence, you find the defendant, fearing that an accusation or arrest would be made against him on a charge involving the indictment, deleted items from his phone, then you may consider same in connection with all other evidence in the case as an indication of proof of consciousness of guilt. It is for you as judges of the facts to decide whether or not evidence of the defendant's deleting items from his phone shows of consciousness of guilt and the weight to be given to such evidence in light of all other evidence in the case. And again, I would give those instructions to you as part of my final charge in the case as well. Thank you. Ms. Fonte, cross-examination.
Thank you. Good afternoon, Sergeant Coles.
Good afternoon.
Going back to when you looked at the hospital video.
Yes.
No, you didn't actually go and retrieve that video, correct?
No, I gave them legal authorization. They gave us the video.
You gave who the authorization?
The security staff. We gave legal authorization to the security staff for them to provide us with the video.
The security staff at the hospital.
Yeah, and they sent it to their legal team so they could release the video to us.
And this is Southern Ocean Medical Center, correct?
It was.
I'm sorry. What was your answer?
What-
I said it was Southern Ocean Medical Center.
Where
You
we-
answered at the same time.
Sorry.
So I just wanted to make it clear for the record. It's Southern Ocean Medical Center.
That's correct.
Thank you. When you first received hospital video back, you said the files were corrupted?
One of the discs had the actual video on it. The other 8 discs only contained hyperlink files to the videos themselves. Since we don't have access to their network, we can't access those hyperlinks, and we're not able to access the video. We contacted the security staff, and then they gave us one DVD that contained all the footage on it.
Now, at one point you said there was a time offset of 3 hours for the exterior video. Correct?
That's correct. Approximately 3 hours.
Approximately 3 hours. I think you said actually 3 hours and 3 minutes?
3 minutes.
Now, that's for the exterior video facing the drive when you pull up to the front of the hospital.
That's correct.
Were you aware that there was a video or camera at the opposing side of the front of the hospital where the ambulance enters?
I was.
Did you seek that from the hospital?
We gave them the legal authorization, and they gave us what they deemed relevant of the investigation, or what they decided to give us is what they gave us.
Well, just to be clear, right, the hospital is not investigating what occurred
No.
when it comes to Corey Michiola.
That's correct.
So when you got back the video and didn't see anything from the ambulance entrance, you didn't follow back up?
We give the video to the case officers. If they wanted more footage, they would request us to pull more footage, or request for more footage.
Okay. The case officers that get the video, they are the ones that review the video?
Primarily.
Is it fair to say that after the case officers review the video, they come back to you and give you the highlights?
In some instances, if it's necessary.
Are there instances where you wouldn't get the highlights?
What the case officers do with the video, like, we fulfill their request. They request the video, we give them the video. If I don't know what they, most of the time I don't know what they do with the video. There's no, criminal proceedings that go along with the case. Except we get, we give, and they review. And again, we review the video to an extent that we make sure what we got is accurate in the sense that it covers the proper time frame. Make sure we, got the right data video. Make sure the video plays back. Most of the time when you export video, it might have a proprietary player that the case officers might have issues playing back with. We always make sure that the footage is in a working capacity before providing it to them.
So when you determined there was a 3-hour and 3-minute offset for the exterior video, did you ever advise the hospital of that?
I did not.
Now, you also mentioned you have a certification in Axiom by Magnet?
Yes,
Now, Axiom is an alternative provider to cell phone extractions, correct?
it is.
You chose to use Celebrate.
I did.
Did you validate your findings with Axiom?
Why would I validate with Axiom?
Isn't it protocol to validate your findings from any particular cell phone extraction provider you use with a second provider?
Yeah, so a lot of this case what I did is I validated those results with online tools. Decode is a date and time conversion tool. I can review the actual database and found the database to be consistent.
Now, so you just didn't use a second provider?
I did not use the second software, no. I'm more proficient with the Celebrate software.
I appreciate the clarification. Prior to the cell phone extraction for, let's for example take Mr. Gregor's iPhone 11,
Sure.
what date did you actually perform the extraction?
The extraction, I believe, was conducted on April 8th.
Of 2021.
That's correct.
Prior to April 8th of 2021, when was the last time you had updated Celebrate?
Well, I didn't do the extraction with Celebrate. I did the extraction with Graykey. Graykey automatically updates.
And what about Celebrate? Did you update that?
We usually use one of the most recent versions of Celebrate.
And after April 8th of 2021, when was the next time you updated it?
When was the last time we updated it? I couldn't recall. Usually an update comes out, it ebbs and flows. Sometimes an update might come out every month. Sometimes an update might come out every 2 months. Usually we'll wait a week or two before you update. Sometimes there might be a bug in the software. If there's an issue, people will report that, and then they'll usually release a hotfix, and that issue might be rectified, and we'll move forward and use that version.
Now, have you ever been in a situation where you've used Celebrate to do the extraction, gotten an update, and gotten more information or data from what you were extracting?
So, only in terms that new capabilities would exist to do an additional extraction that wasn't previously available.
Can you explain?
Sure. So, we did the full file system extraction of Ms. Michelot's cell phone. That is the highest tier extraction possible to do for that cell phone. If we were to redo that extraction, we'd actually probably get less data because, again, sometimes system files or internet history might automatically purge after 30 days. So, usually the first time you do it, if you can do the highest tier extraction possible, will be your best outcome moving forward.
Now, in terms of Ms. Michiolo's cell phone. You received that on April 23rd, 2021?
Miss Mitchell's cell phone?
Yes,
No, it came in April 3rd.
came on April 3rd.
Yes.
Now, is that the only cell phone that your office received from Miss Michiolo's household?
I believe it was.
And when you did the extraction for that cell phone, Miss Michiolo's cell phone, did you check to see if any of the data was corrected?
First, I didn't do the extraction. Detective Nathan did the extraction. The extraction opened up fine without any issues. Did not appear to have any issues. When the extraction completes within the Celebrate software, it'll say file system extraction completed successfully.
Did you check to see if any of the information or data on the cell phone had been compromised, is what I'm asking?
In what capacity?
In the capacity of, is it not true that you can create fake text messages?
Certain applications and third-party apps, you could make, I guess, send out a fake text if you want to, like a spoofing application.
Anything like that, yes?
Yeah, it's possible.
Now, you had mentioned you had come to the opinion that messages and search history had been deleted, correct?
That's correct.
Now, you're unable to say when those items were deleted.
An exact time, yeah.
I'm sorry.
I'm unable to say an exact date and time when those were deleted.
And you're not able to say if it was done manually or automatically.
It depends on when it was deleted. So, again, if the system states messages are retained forever and they're missing, it would be indicative that it was deleted manually. If it goes back for 30 days and records in those 30 days are missing, again, it would be indicative that it was deleted manually.
But here you can't say when.
For this, I mean, I can give you an approximation, but the exact date and time, no.
Now, the prosecution had led you through a series of text messages marked as S144, I believe, to S159.
Sure,
And those series of text messages that you read out loud to the jury, correct?
I did.
When you read them out loud, is it fair to say that you're reading Mr. Gregor's text?
I believe so.
So I'm going to point you, for example, to one prosecution or state exhibit S10.
Sure.
Do you need a copy?
I do not have a copy of here.
Can I have permission to approach the witness?
Yes, sir.
Sorry, I'm showing you S10. Let me know when you're ready.
Thank you. Yes.
So S10, you actually read Mr. Gregor's response, correct?
Well,
Let
it's
me
not.
withdraw. On
Sure.
correct, you were asked what the text message was that Mr. Gregor sent, and you read it.
I did.
Prior to that text message, though, on that same page is a message from Brianna Michila.
That's after. It was sent after. You said prior.
But there's another message from Brianna, correct?
There's a second message on here from Brianna.
And it says,
Or sorry, I'm looking at this like it's Chris's phone. Yes, it's from Brianna's phone. Brianna is on the right side. So, I apologize.
No, it's fine. I appreciate the clarification.
Sure.
So there's a message that starts from Brianna first, correct?
There it is. That's correct.
And that message says, where are you?
It does.
So to put Chris's message in context, the response is, I'm home, send Corey inside.
No, let Corey walk inside the house. Yeah.
Thank you. I appreciate the clarification. I'll just take that back. Judge, can I approach? Would you like me to approach, or did you want me to ask?
You don't have to ask, you can give a brochure.
Thank you. Now, in terms of the messages, S44 through approximately S159, I'm going to correct myself, S144 through
Sure.
approximately 159, those are all coming from Mr. Gregor, correct?
I'd have to see it again, but I believe that was the ones that were all sent from his phone.
Yes.
Yes,
And each individual text message was marked as a separate exhibit.
that's correct.
But fair to say there's a conversation happening with the other side.
There is.
Now, depending on who the other side is, sometimes it was, what did you say it was Marcy was her name?
Marcy Brogna.
And sometimes it was Laura,
It was Laura.
right? But there's conversations and text messages going back and forth, correct?
Yes, that's correct.
The state, for your testimony, highlighted Mr. Gregor's responses.
That's correct.
Now, you noted at some point that Mr. Gregor's cell phone went into airplane mode.
It did.
What was the date of that?
Sure. Let me just pull up the chart.
Thank you.
So the date was April 2nd, 2021.
What time?
The first time it went to airplane mode was, sorry, I'm just trying to do the conversions from UTC to Eastern, 6:09:51 p.m.
And at 6:02 p.m. that same day, he received a message from Ms. Michila.
Yeah, he took the phone out of airplane mode at 6:09:54.
He took it out of airplane mode.
That's correct. And then it was put back in a little bit later.
And at 6:02, he received a message from Miss Micciolo.
That's correct.
Now, during your direct testimony, the state went through the hospital videos.
We did.
correct? And there was one video where you see Mr. Gregor walking down a hallway into a room,
That's correct.
and I believe that was marked at approximately 4:54 p.m.
Sure.
And I say approximately because I don't think there's a time effect.
No, just the exterior video.
And there was a second video where he's leaving that room with the male escort,
Yes.
and that was about 5:12 p.m.
Yes.
And the exterior entrance is marked at 8:23 p.m.,
Yes.
correct?
That's correct.
But that is again a 3-hour and 3-minute offset.
So it would have been about 5:20 p.m.
Thank you. You also mentioned that during your direct, there was an unanswered call at 8, withdrawn. There was an incoming call from Mark from DCP&P on April 1st, 2021,
Yes.
and that lasted 3 minutes and 44 seconds,
I'd have to look at the call log, but I believe that sounds right.
approximately.
Yes.
Can you hold a moment?
Sure.
Thank you. Now, when the cell phone extraction was performed, the way you view it, I'm going to describe it as a dialog box with different tabs.
It can be described that way.
And there's a section that says web history.
There is.
There's also a section that says applications usage log.
There is.
Now, is it fair to say, in your experience as an expert particularly, that I can access some applications through Safari?
You can.
So, for
Or
example,
you mean like access the app through the web browser?
correct.
I mean, I would describe it like this. If I was to go on Facebook, just use Facebook for an example, for illustrative purposes. If I was to go on Facebook.com and access Facebook through my web browser on my phone, I could use Facebook with the web browser, or I could open up the Facebook application on the phone. For instance, if I wanted to chat with somebody and using Facebook on a Safari web browser on the iPhone, you'd probably have to go to like a desktop view in order to use the web browser. If you try to use the message, it'll probably ask you to open up the Facebook Messenger application. So in that sense, sometimes the website would trigger you to open up the application.
Well, when you receive the results, and I phrase it like that because sometimes you didn't always pull the extracting yourself, correct?
That's correct.
So when you receive the results and you look at it and you're asked to analyze it, did you do a side-by-side comparison of the different items?
In regards to...
So you received the results from Brianna Micciolo's phone.
Mhm.
That would have been on one report.
That's correct.
And then you had the results from, say, Mr. Gregor's iPhone 11 on a different report.
That's correct.
Did you do a side-by-side comparison of those two?
Only for text messages.
And at one point, the state actually asked you to focus, I believe, on 7 different items they call tasks.
Sure.
And that became your focus.
It was.
And you made sure to answer comprehensively those specific 7 questions.
That's correct.
Now, when you did the favicons that you talked about, am I saying it right?
That's it.
That was for Pizza Hut.
That's correct.
Did you see any other favicons for other searches that you couldn't quite find?
I did.
You didn't look at those.
I saw what they were. I can tell you where he came from before he went to Pizza Hut.
Were you asked to dig into that? By the state?
They were curious of what deleted history was.
Now, I'm going to ask that you take a look at what I've marked as Defense Exhibit 14 and 15 for identification.
Can I?
Oh, I apologize.
From your button. Let me just take a look.
screenshots essentially of part of the result from the application's usage log and the web history.
That's correct.
Now, looking at the web history first, April 2nd, 2021. Very top line, 3:49:50 a.m.
Sure.
Looks like someone accessed Gmail.
No. So inside the Celebrity Physical Analyzer software, right here, you have a little drop-down arrow. The emails are also in there as well. So these would be emails on his phone, not associated with the Safari web browser.
Now, looking then at the next exhibit that you're holding for application usage log. Top line, April 2nd, 2021, 3:49:54 a.m. That's about a 4-second difference, correct?
Where are you at? The top line, 34954.
Yes.
Yeah.
Going back to the last exhibit.
The web history one.
Yes. Thank you for bearing with me as we shuffle.
That's all right.
April 2nd, second line down from the top, 2021, 12:36:20.
Yes,
It's again marked as Gmail as the title.
that's correct.
Going back to that second exhibit you're holding, 15. April 2nd, 2021, second line down, 12:36:14 p.m., correct?
Yep.
And again, we're comparing the Gmail or the application's history log with the web history log, correct?
That's correct.
I'll take those unless you do.
Yeah, you can take them.
Now, in terms of the gym videos,
Yes,
and again, that's at the Atlantic Apartments, correct?
Atlantic Heights.
Atlantic Heights. You focus your time period for the gym videos from March 2021 to April 2nd, 2021.
The initial pull request was that time frame.
What was the focus after the initial pull request?
Everything from the gym, as far back as the DVR went.
And which videos were viewed?
I couldn't tell you which ones the case officer reviewed. I assume they went through most of them.
In terms of as far back,
Sure.
right, that statement you made, how much gym video did you get?
So the video went back to January 30th. It's approximately, if you add both together, it's like 90,000 individual clips.
And did you personally watch all 90,000?
I don't know.
Is it fair to say that there might have been some case officers that watched pieces of those 90,000?
There were.
And I presume, correct me if I'm wrong, they would come back to you and again highlight certain videos for your interest?
Yeah, if there's anything there.
Now, you saw a gym video, was it March 20th, 2021?
I did.
Did you happen to notice a gym video from March 29th, 2021?
I believe they might have mentioned it. I don't recall watching it.
In the videos that you did watch of the gym, again focusing on March 20th, 2021 through April 2nd, 2021, did you see other videos of Mr. Gregor and his son just working out in the gym?
There were.
Judge, can I have one moment?
Certainly.
Last question. How many videos did you see of Mr. Gregor and son just working out in the gym without issue?
Without the issue?
Yes.
And I didn't see them, I spoke.
Objection, what's the issue?
I'm not sure what the objection is, to be honest.
The issue being an allegation of some wrongdoing on March 20th and not on other occasions? Is that what you mean by that?
Yes.
It's permissible. Overruled. You can answer it.
Sure.
Did you need to repeat the question, or you
You said how many instances did I view personally of them working out without issue?
in that time period? Yes.
In the time frame from like January 30th up until April 2nd?
Yes.
I think there might have been somewhere between 8 to 10 instances of them, at least.
Thank you.
And can I just elaborate on one other thing, too, with your web history, just to make sure it's clear for everybody else
I
involved?
would ask to leave that for redirect. I presume
Sure.
ask you questions.
Very good.
Any reader?
What do you want to elaborate on?
Can I just see the web history, or the quote web history in the Safari browser?
I'm not sure if this is what you're referring to, but
It was the
S122?
defense exhibits.
The
two
defense
defense
exhibits. Are you sure exhibits?
D14 and 15.
D14 and D15, you didn't create these, right?
I did not. I just
Did you
saw
ever
them.
see these before sitting on the stand today?
Just today, just now.
Okay, I'm approaching with D14 and D15. Could you take a look at them?
Sure.
And explain what you wanted to explain?
Sure. So before we're comparing our usage to the Gmail history, web history, these listed date and times on here are the dates and times emails were received, not indicative of him utilizing the Safari web browser. That's pretty much it.
With regard to the deleted text messages in the defendant's phone with Ms. Michelow, were you able to eliminate the idea of spoofing because the entries were actually missing from the defendant's phone when the text appeared in hers?
So
Objection leading.
It's appropriate to redirect him back to a topic that was a board undirected for us, so it's permissible.
Were entries actually missing from the defendant's cell phone?
yeah, so to elaborate on both points, right? The text messages in this case were from the MMS SMS.db. This is the native messaging application for an Android device. It was not from a third-party application. Her phone was not rooted. She did not have master access to really go back and modify that database in any way to spoof messages. In regards to the messages on Mr. Gregor's phone, they were just completely missing. And again, sequence gaps within the SMS database were consistent with messages that were sent from Ms. Michelow's phone.
Okay, and on cross, you had been asked a question about whether you could tell when a text message is deleted, and I think you said you could approximate it?
Again, depending on when the search was conducted or the type of search or type of deletion was done, obviously the deletion has to happen after the last message was received, or else, it wouldn't be there. Can I say when a text was deleted, or, hey, maybe text came in from Brandon and got deleted today, and then more text came, let me phrase that again. Say Brandon sent Mr. Gregor 10 text messages on May 1st. Mr. Gregor could have deleted them on May 1st. Then Ms. Michelow sent Mr. Gregor 10 more text messages on May 2nd. He could have deleted them on May 2nd. All I can tell you is that deletions happened after the device occurred. In regards to deleting stuff within Safari browser, Mr. Gregor's phone was missing. I could tell you the exact date and times of when searches were missing. So if we look at the sequence gap on Mr. Gregor's phone, in this case, it goes from 44134, then it goes to 44359, 44360, 361, 362, obviously with the 4 4s in front of it. So we can see there's a sequence gap of approximately 225 missing text messages. 225 missing entries in his web history. In the Safari browser, you have 5 different ways you can delete text messages. 5 different ways you can delete your search history. You can either A, individually delete entries piece by piece. B, you can delete your history by the last hour. C, you can delete history by today. D, you can delete history by today and yesterday. And E, you can delete everything. In this case, I would approximate, since the first entry on here at 44134 is on April 1st, 2021 at 2:58:16 a.m. Again, we need to realize that time is in UTC, not Eastern Daylight Time, so that entry would actually refer to a time on March 31st, 2021. The first entry, that 44359, the date and time of that is April 2nd at 9:14:44 p.m. I know the last Conscious and Sleepy was one of the last searches that was conducted. Again, I can't give you an exact time when it's conducted, but at some point after 3:08 p.m. Eastern Daylight Time, but before 5:14:44 p.m. Eastern Daylight Time, it more than likely occurred that Mr. Gregor hit the delete today and yesterday search, as there's no message on April 2nd prior to that, and then there would be obviously no recent saved searches from April 1st.
I have nothing else. Thank you.
Any reproach?
Just briefly, Judge. Referring to D14 and 15 for identification on
Sure.
pages that showed this.
Yes.
You didn't see those pages before today as they're prepared, correct?
No, I mean, indirectly, like looking at the physical analyzer software we took the screenshots from, like I've seen the screen of where these would have been pulled from before. I can see that came from these phone extractions. These two actual printouts, I have not seen before today.
But you've seen that information in the extractions that you have, correct?
I have.
And in terms of deleting text messages,
Yes.
you mentioned briefly that redirect.
Mhm.
I could also just swipe left and delete the entire conversation in one motion, correct?
You can.
No further questions.
All right, Detective, thank you for coming in.
Thank you very much, sir.
I see Counsel Summer. Members of the jury, thank you so much for your attention today. We're going to recess till tomorrow. I discussed with the attorneys the schedule. I think you can arrive about 9:45. So a little bit later, take your time getting here, and then we'll get the jury assembly 9:45 or so. Hopefully we'll have you over here by 10. We'll start at 10 with our next state's witness. Again, don't discuss the case with anyone. Don't do any research. Don't look anything up. And when it does come up to you and tries to discuss with you, don't tell your fellow jurors. Report it to me immediately. Continue to tell your immediate family and your employer that you're just on jury duty and don't have any further discussions about it. Anything from counsel before we have the jury retire for the day?
No, Judge, thank you.
Thanks so much, ladies and gentlemen. We'll see you tomorrow.